Hi, I'm Tom Alston, and I have another tragic story to tell you. During a recent conversation with an aircraft broker in the Great Lakes area, he told me he has no problem with the California tax people. He indicated the underlying foundation to this viewpoint is that he's confident that California's attempts to tax out-of-state domiciled aircraft would be overturned in federal court. Therefore, he feels like his clients are not in danger. I reiterated California's position that all aircraft are subject to assessment by California if they enter California at any time during the first 12 months and are discovered here by the tax people. I could sense resistance building in him as he became a bit emotional and restated that California state law can't overcome the federal court system. I brought up that if an aircraft enters California only once during this initial 12-month test period, and I agreed that it's a bit like a needle in a haystack proposition, it is a technical possibility for California to find him, and they will assess him tax. My refusal to make him right for his opinion only served to reignite his passion for his position. So I backed off, trying to convince him of what is my reality and that California can and will do whatever it wants, hence the title of this article. First, I will define the phrase reality break. My definition here of reality is agreement. That's where two people see eye to eye and agree that something is true. My definition here of break is where something is broken or out of alignment. Therefore, when I use the term reality break in this video, I mean that the broker and I have different opinions of what is true. We are both equally convinced that our opinions are correct. I finished the conversation with an offer that anytime he has any aviation tax questions, I will help him. I told him, even if I'm not an expert in the area of the question that you have, I'll find you the person. I've been in this business long enough that I pretty much know all the really good people to talk to. He thanked me, and he seemed like he was a bit more relaxed, so I added the comment, you can call me anytime and argue with me about California sales tax. He began laughing uncontrollably. Mission accomplished. I had diminished this level of emotion that had begun to build this wall between us. For example, let's say I'm wrong and he's right, that an out-of-state resident will always win in federal court regarding this issue. Here's the problem. I'm very concerned about my client's money. The business I created is based on eliminating a tax that adds to the cost of your aircraft. Therefore, it is my position that people don't waste money on taxes or tax ideas. I also always talk people out of hiring me if the tax savings doesn't overcome the cost of my avoidance program. If an out-of-state owner is assessed tax by California, he is normally advised of this by mail. So you'll, as the out-of-state owner, will take this card or this letter from the state of California to your local CPA, and he'll tell you that you're not a resident of California, therefore California can't do anything about it. The state of California sometimes later, because they're convinced they're right, will file a lien on your aircraft. The FAA will always accept and record a state of California tax lien on your airplane. See where this is going? Everybody's right. State of California is right, I'm right, and this broker in the Great Lakes area is right. The problem is, once this lien has been filed, you could be in violation of your finance agreement or your insurance policy. This will cost you some money to justify the lien to your bank or to your insurance company. This effort costs something, whether it's handled by your representative or you do it yourself. Even if it's just the annoyance factor for you, it's got a cost to it. If the aircraft is mid-sale, the whole sales process can be ground to a halt, and you'll lose your willing buyer. This costs you something. Secondarily, by law, this case cannot go to any civil court if you don't give the state of California an opportunity to go through their whole evidence gathering process. You have to do this, or you can't get your case with the state of California into civil court to get it to federal court. This will cost you something. You'll have to circle back to the beginning, go through the entire audit process. Anyway, this costs you money and a lot of aggravation. Now here we've gone through their whole process, and let's say they deny your claim for the exemption. Okay? According to this, the only option you have at this point to get it into civil court is you have to pay the tax. And what you need to be advised of is even if you go through their process, you cannot and will not be reimbursed for your legal costs. This is starting to cost you a lot of money and immense aggravation. If you lose at the state level and take this to federal court, you start the process all over again. This is beginning to cost as much as your aircraft does. That's why I know my approach is saner. I will guide you through the process, assist you to gather the correct paperwork right from the beginning. I am the lowest cost option when you compare it to the route that is taken by people who want to fight with the state of California, even if you're right. So it costs you, in this case, it'll cost you a lot of money to prove that you're right. And you may be, but it has a large cash expense attached to it, a lot of aggravation attached to it. If you go through it my way, there's no aggravation. There is some expense, okay? So call me. I'm Tom Alston, 916-691-9192, extension 108. Remember, this may sound funny coming from a tax professional, but my approach is the cheapest way for you to go. No aggravation and not a lot of money. Thanks.